lead students in prayer. There can't be kind of this government-endorsed or sanctioned prayer in public schools. And so he eventually got fired, basically, or his contract not renewed, because he did not want to stop having this kind of moment on the 50-yard line. The ruling today, with a 6-justice majority, the vote is 6-3, the Supreme Court has sided with the football coach and emphasized that simply because you're a teacher or a public employee, you cannot be prevented from expressing or your religious views if they are personal and private. And here a justice emphasizes this also wasn't a lull in the action. It wasn't in the classroom. And so that's why I say this decision is narrow, and the court goes to great lengths to say they're only addressing this unique moment where the coach was wanting to take a knee. Yeah, and they're not getting into the bigger questions about the broader rights of public employees and teachers in general. They emphasize that this decision is only limited, and of course, school districts can continue to kind of restrict some of those kind of prayers and teacher-led prayers.
Yeah, Jen, I think it's very interesting reading the decision. They say Mr. Kennedy did not offer his prayers while acting within the scope of his duties as a coach. But as you say, these prayers were actually on the 50-yard line. They were happening, as though the justices say, during a downtime. I wonder what implications that has in terms of separation of church and state when it comes to being on school grounds.
No, that is the question, right? And of course, there's a lengthy dissent, which I haven't been able to get to quite yet, because we've just gotten the majority. But to put this in perspective, this is a Supreme Court that really believes the pendulum has swung too far against religion. And so there were arguments in this case that if the football coach lost, that would prohibit people from saying a private prayer in the school lunchroom, a teacher, during lunch, if some student may have seen her sitting at, the school cafeteria table. The other side said, no, that's not what this case is about. But I think this court is very concerned that in this effort to kind of erect this wall between church and state and not establish religion, that is swung too far and is actually showing hostility toward people having any religious beliefs at all. And so this case now is saying, if you want to take a knee after the game and just say a prayer, go ahead and do that. And it emphasizes the private nature of that. It doesn't really get to the point of, and it suggests, of course, that the coach still couldn't gather the team around and lead them all in a prayer, that's not what's at issue here. It's just the private, solitary moment of reflection that this coach had wanted to do. And the court is saying, that's okay.
So interesting that they think of it as private when it was so obviously very public, him being there on the field.
Yeah.
And that's the point of it, right? I mean, that's the point. If you want to just take a knee and say a silent prayer to yourself, that's your moment of private reflection. And if the government is saying you can't do that, then this court suggests, although this was a free speech case, that this is hostile toward religion. So again, it's that pendulum and where this court is going to be. And while this case is narrow, certainly it is clues to where this court is going to go in future cases.
All right, Jan, stand by, because I want to bring in Jessica Levinson here to provide some more legal analysis on this. So, Jessica, you just heard Jan's breakdown of this ruling. The ruling was 6-3 in an opinion by Judge Gorsuch that the public school officials have a constitutional right to pray publicly and lead students in prayer during school events. And I'm struck by the point that Lana made, where I'm reading here in this opinion, the timing and circumstances of Mr. Kennedy's prayers during the post-game period when coaches were free to attend briefly to personal matters and students were engaged in other activities confirms that Mr. Kennedy did not offer his prayers while acting within the scope of his duties as a coach, especially that last line, duties as a coach. I mean, if a teacher isn't in a classroom, but he happens to be at that football game, he's still a teacher, still employed by the school, still held to the responsibilities of the school. So help me understand what Judge Gorsuch is saying.
Well, I think Jan is exactly right here to emphasize, and you're emphasizing in it that question, that what the court found here is that the football coach, Mr. Kennedy, was really engaged in a private prayer. And therefore, this does not extend to the situations that you talked about, which is what if he was in fact engaged in, he was there as a football coach during the game. Let's say he called a play and then he said for a moment, and let us pray. The court's saying that that's not this case, and we don't need to try and decide this case. But the question that you asked, Vlad, I think is exactly right. And it's a question that we heard during oral arguments where that was the threshold, right? Is this public speech or is this private speech? You only get to this decision, you only get to the opinion where we find that, in fact, his First Amendment rights were violated by finding that he was engaged in this private moment. Now, I will say there were plenty of facts in this case where I think there was room and the dissents would have found that you could potentially go the other way. He's there because he needs to be as the football coach. I believe he's wearing a uniform. Yes, he has a moment that to himself, but he is still in charge of the students. He's still there in his official capacity, I think could be the counter argument here. So again, that was the threshold question that the court was trying to get past. Once you find that it's this private moment, I want to echo what Jan's saying, it's a narrower decision and it's a continuation of what we've seen from the court. I think she used the words, the pendulum swinging back. It's exactly right. It's this court saying, we're worried about not protecting people enough under part of the First Amendment, the free exercise clause, the free speech clause. We're worried that we've done that because we've cared too much, basically, about the establishment clause, the idea that the government shouldn't favor religion over non-religion, one religion over another, et cetera. And I think that's what you see from the court today, this continuation of the recalibration.
Jessica, I want to follow up, though, on that point, because as you say, he was in his coach's uniform, it was on the field. And as I understand it, several times he was actually joined by other students. So it wasn't actually that private prayer, as I think of, when it's a communication between yourself and your God. Did that factor into this decision at all? The fact that students were oftentimes involved in this prayer?
So I haven't gotten to go through the entire opinion yet, but the idea that the students willingly joined him, I think, was different from, let's say, you start a school day with your teacher saying, and now before we get to geography, let's have a moment where we all pray. That was different from, I think, what the court would say. Maybe this is more analogous to a teacher on a break. Students see that teacher praying, decide of their own volition that they want to join. I think when it comes to, what's the purpose behind the protections for the free exercise clause? What's the purpose behind the protections under the establishment clause? In part, it's the idea that people, including students, shouldn't feel like they need to join their teacher, their high school football coach, because it's someone in a position of authority representing the government who is basically pushing the idea that they should pray. That's not the route the court took today. I think we should be clear on that. That's not the route the court took. The court didn't say this is like a teacher walking into a classroom and saying, let's now lead a prayer. The court decided this is more of a private situation. Students decided to join him. That's how we get to this analysis of the free exercise clause. That's how we get to the 6-3 conclusion.
And Jan, I'm going to ask you for your reaction to this, having covered the Supreme Court for all the years that you have. And Jessica wrote about this in a piece that was posted on, I believe, NBC's website, that we kind of got a sense of how they were perhaps going to rule, because back in 2019, Samuel Alito joined the other three conservative colleagues and said this about the Ninth Circuit's decision upholding what the school board did. What is perhaps most troubling about the Ninth Circuit's opinion is a language that can be understood to mean that a coach's duty to serve as a good role model requires the coach to refrain from any manifestation of religious faith, even when the coach is plainly not on duty. But I'm not a lawyer, but not on duty. In my mind, you are on duty. You're there coaching the game. But I know it's very narrow.
Jessica said is that this involves a moment of private prayer, and we can talk till the cows come home that taking a knee on the 50-yard line is not a private prayer, but it is a silent prayer. Maybe we should say a silent prayer, which he just started doing to himself. And this is not about teacher-led prayer. This is not about coach-led prayer. That's not at issue right now. They're focused only on that moment that Mr. Kennedy, Coach Kennedy, wanted to have on the football field. So this does not call into question right now whether teachers, that's still impermissible. Teachers cannot lead prayer, students in prayer. Coaches are not supposed to lead their players in prayer. The question is whether Coach Kennedy has a right, a free speech right under the First Amendment and the religious clause to express his own religious beliefs. And this court believes that the law has gone too far, and so it actually, in some ways, if I can shorthand this, discriminates against religion, because, you know, you can basically say anything you want to yourself unless it's something to do with religion. So this opinion suggests that, you know, setting aside, we're not talking about teachers leading prayer. No, that's not, we're not saying that that's permissible. Coaches leading prayers in the locker room, that's not at issue here. That's still impermissible. But if a public school employee or someone who's acting out of the bounds of his employment during the school hours, or whatever the court characterized it, I need to get back more into how they're characterizing him. There is some disagreement on that. If they want to have this silent prayer to themselves, that's okay. And if you're not going to allow that, then what about, you know, a teacher who wants to just bow her head in the school cafeteria, as I said? That's something that they see as totally different than teacher-led prayer in the classroom, which the First Amendment and the Establishment Clause would certainly prohibit.
So, Jessica, going back to the piece that you wrote recently about this case, you do point out that, so what if I'm a student of Jewish faith, or I'm a Muslim, and I see this is happening, and I see my other teammates circling around this coach to engage in this prayer. And here's what you wrote. Let's remember that Kennedy can, in fact, exercise his religious beliefs. The school district here is merely asking him to exercise those beliefs when he's not acting in his official capacity as a public school coach. This actually protects our freedoms. Students who are members of another religion, not members of a religion, or who don't want to publicly display their religious beliefs are free from the pressure or coercion caused by these situations. And you point out that this is a steady march, you call it, of the court's preference over individual freedoms rather than the freedoms that allow all of us to live in a society free of government endorsement of religion.
Well, I think one thing to note about the piece is that the court didn't find, in fact, that he's acting in his public capacity as the football coach, that he's a football coach who still retains, I was just looking at the language of the opinion, who still retains rights as a private citizen. But to pick up on the point, Vlad, that you were just talking about, this march towards what I see as enlarging the free exercise clause, the free speech clause, frankly, to the detriment of the Establishment Clause. Let's think back to the decision that the court made last week. It was a decision about Maine. They decide to create a public tuition assistance program. And they say to school-age families, school-age children, you can use this money. You can use this money at private schools, but you can't use this money at religious schools. And to pick up on a point that Jan made, the court viewed that as discrimination against religion. That's what the conservative majority said in that case. And I think we see, again, a similar, obviously very different cases with different facts, but a similar rationale here, which is if we didn't allow Mr. Kennedy to engage in this private prayer, we would actually be discriminating against religion. We need to recalibrate. We need to allow him to do that. This court doesn't view that as officially endorsing religion, creating a government religion, or favoring one religion over another. Now, pause, separate from that, in practical effect, if you're a football student on that field and you have a different faith, or you do not have faith, then might you feel uncomfortable in that moment? Of course. I think the court's response to that would be, but we can't make Mr. Kennedy, we can't burden his individual rights just because you might feel uncomfortable.
I want to show our viewers a quote from the dissenting opinion. They say, if we can put that up, guys, that the Constitution does not authorize, let alone require, public schools to embrace this conduct. This court consistently has recognized that school officials leading prayer is constitutionally impermissible. The court now charts a different path, yet again paying almost exclusive attention to the free exercise clause protection for individual religious exercises, while giving short shrift to the Establishment Clause's prohibition on state establishment of religion. I want to ask a clarifying question on this, because as I'm reading the opinion, they're talking about quiet prayer, not silent prayer. Jan, I noticed you used the term silent prayer. Do we know if, in fact, these prayers were silent or if they just weren't weren't offered an allowed voice, that they were still being
still hearing religious language.
Right. And does
So-
that make a difference?
So that kind of goes to the messy nature of this case and some of the very different things that happen on that football field at the end of a game with Coach Kennedy. At first, he started taking the knee, praying to himself, and this kind of evolved, right? Then a few players joined. Then he starts speaking out loud. He starts saying a few words. Then players from opposing teams. So then it's kind of grew into this big circle in the middle of the field with players taking a knee with their helmets. He's holding up the helmet, and he's actually speaking publicly.
He's holding up his helmet during this, which is
Correct.
interesting
And
because in the opinion it says Mr. Kennedy did not offer his prayers while acting within the scope of his duties as a coach. His physical representation of holding the helmet seems to cause that to be a public
that's
a
why
public
it's
display.
kind of you can't stop there though. So then you have to go. The court said so. The school said like no, you can't do that. Like just stop. No. And some parents had complained. Not all the players were participating in it. In fact, the two captains didn't participate in that. But they're like no. So he said okay, fine. And that's fine. And so the case and what he was asking for was just this ability to just be by himself, essentially, and to return to his original purpose. He was fine with that. And so that's kind of what the court is addressing now. They're not saying at all that coaches or teachers in public schools can lead students in prayer. They're focusing on whether or not Coach Kennedy can just kind of say this silent or quiet prayer of reflection to himself. That's what they're saying. And if that is impermissible, then that would violate his rights under, as Jessica said, the free exercise clause, his right to free speech, essentially. And that doesn't, so therefore they're saying that allowing that must be allowed under the free exercise clause, and it would not look like the government is endorsing religion or establishing religion. Again, as Jessica and I were both in agreement on this. I mean, this is a court that is going to recalibrate some of the tension between those two clauses that this court thinks has gone too far the other way, and is now, in the fears of making it look like government is endorsing religion or establishing a religion, it is singling out religion and cutting it out of the public square. And that ignores the whole other section of the clause, which is that you have a free exercise right to practice your religion. And so they're recalibrating this right now, and Jessica's 100% right. That is exactly what they did last week, and allowing, in refusing to allow and stopping the state of Maine for kind of hollowing out religious schools into this widely available program where parents who lived in areas, very rural areas in Maine, where there were no public schools, the state had a program that they could access funding to send their kids to private schools, unless those private schools were religious. And so last week we saw the court saying, well, if you're going to make this generally available program, you cannot, keep these parents from being able to access it to send their kids to religious schools. Like the concern, again, the bottom line is that we've gone too far, and so religion is being treated with hostility in the public square. So they're swinging it back a little bit. They're not saying, though, in this case, that teachers can lead students in prayer. You can have a prayer over the public address announcement by a teacher, before school, before a game. Coaches can't lead their teams in prayers. This is more about whether or not a coach like Mr. Kennedy has that, where they're not instructing students, where they're just sitting in the school cafeteria having lunch, can have that kind of quiet expression of religion. And the court is saying, yes, they can do that.
So, Jessica, you teach young potential lawyers in the classroom. Explain to our viewers what the Lemon test is and how this perhaps relates to that test, if in fact the Supreme Court is sort of overruling the Lemon test and the endorsement test, which I know law students learn about all the time, and what it potentially means for the future.
So I don't think the court is. And if I could actually first pick up on something that Jan was saying, I have the benefit of being able to look at the opinion while she's explaining the opinion. And she's focusing on this idea, and this is Vlad, to part of your question about why I don't think this is undoing past precedent, is the court really is, and I should have been careful about this, focusing on these private moments. And here's why the court thinks that this is not, in fact, public speech. The opinion of the court says he was not instructing players, discussing strategy, encouraging better on-field performance, or engage in other speech the district paid him to produce as a coach. Simply put, Mr. Kennedy's prayer did not owe to their existence to Mr. Kennedy's responsibilities as a public employee. I really think that that's what this case is about. Getting to, tests like the Lemon test, getting to tests about whether or not the government is in fact encouraging the endorsement of religion, let's say. What this court would say, I believe, is we're not touching that. We're talking about somebody who, yes, was on the job, but just because you work at a public place, just because you are at a high school, or you are after hours at coaching a high school football game, that doesn't mean that you give up all your rights as a private person. And so I think Jan is right. This is analogous to more the lunch break. This is analogous to the snack break. And I think actually the court went to pains to do two things that we're both saying. One is to try and say it's about private speech, but the other is to say, and because it's about private speech, we are not going to discriminate against it. And it's the theme that we've seen now, as we talked about that case last week out of Maine, the public tuition assistance case. There have been some other similar cases over the last about 2 or 3 years where the court has talked about whether or not a religious organization could, for instance, repave the playground in a school. And the court has this consistent theme of we will not discriminate against religion. Again, being more worried about that idea of discrimination, in my view, than for now worried about the idea that we're endorsing an official religion.
Mm-hmm.
And if I could point out, again, that's yes. And that is a trend that started, unlike our cases last week, that is a trend that started before we had the 3 most recent nominees to the Supreme Court. So we have seen the case that Jessica mentions on the playground equipment. That was, if I'm, again, off the top of my head, I believe, Jessica, that was in 2017. I think that's when that case was. And so this court has been moving, even the old court, before we got the 3 new Trump appointees, this court has been moving in this direction. And there are 6 votes for it now. Mm-hmm. But this is not the kind of case where, you had one more justice come on, replace Justice Ginsburg, and then the whole world changes.
Well, it will be interesting, of course, to see what happens after this. Jan and Jessica, thank you so much. We'll be right back.
An original documentary from CBS reports.
It's gonna be big!
The metaverse, the virtual world that's become a cryptocurrency casino.
It's like buying property on Mars.
Do they get an actual picture of this? No, it's a digital copy. Why would they pay for that?
Making millionaires almost overnight.
We made more than $1 million in crypto last year.
I have no idea how much money I have made over the past year. That's like, wow.
Big rewards.
There's gold in them, there are hills, as they say.
Bigger risks.
The market's down, but it's gonna bounce back. It's crypto.
Is it a gold rush or fool's gold?
It's our metaverse, our story. Peace out, y'all.
An original documentary from CBS Reports. Stream now.
I'm Nora O'Donnell in our nation's capital. We're here at the White House with the President of the United States.
Thanks for having me. I appreciate it.
We've never done an interview like this before.
That's correct.
Tonight, a congressional investigation sparked by reporting from CBS News. What's your message to consumers?
They need help now. Tell him I feel it.
The CBS Evening News with Nora O'Donnell from Washington, D.C. on CBS and streaming on Paramount Plus.
We will witness yet another moment in history.
This week on 60 Minutes,
That's incredible.
The 60 Minutes.
60 minutes. 60 minutes.
Are you ready for some tough questions?
Let me ask you this.
you know how this sounds.
What's your response to that?
60 Minutes Sundays on CBS.
The threat of severe weather and dangerous tornadoes is expected to last.
Let's get the forecast from our partners at the Weather Channel.
Here we are in our virtual view.
Now 6 feet of water, imagine that. Cars that can act like battering rams.
These hyper-realistic simulations show you what the weather will look and feel like before it happens.
This is our virtual view, what it actually looks like. Those are some of the best graphics I've seen.
Spare no expense, Gail. We experience the weather in a whole new way.
Go to the ends of the earth.
Right now.
We got something crazy. And reach for the stars.
Here we are.
Time.
Yes, it's my comeback.
Hey, this is pretty fun. But wait, there's more.
Experience thought-provoking.
Welcome to the idea of being a human being.
Innovative and truly original reporting.
Look through a telescope and go, wow.
Because there's always something new under the sun on CBS Sunday morning.
People from every corner of America facing challenges.
Everyone is just looking for some type of connection.
Just raise